All right, everybody, welcome back to the Learning Out Loud podcast. I'm your host, Dustin William. I have my co-host with me, Whitestone.
It is undeniable that a vast proportion of the actual doctrines and rules which make up the system of equity are necessarily inferences from or direct applications of some or more of these fundamental maxims.
The power is neutral. It's sitting in the quintessence until you invoke it. Behind using these things are good and holy and Christ-like.
I shall now attempt to show how the most important of these principia have been crystallized into the pithy form of maxims and have influenced and developed that grand system of truth known as equity jurisprudence.
All right, welcome everybody to the Learning Out Loud podcast. This is episode 3. I am your host, Dustin William, the owner and producer at True Life Productions. You can see all of our content at truelifeproduction.com, such as our flagship show, All Aboard, where we get into the history of New York and the orphan trains. Specifically, I just released episode 8 on that, where we start picking apart Charles Loring Brace's little journey through Europe. It's getting pretty interesting. Go check it out. And then after that, you can check out Article 3, Articulations, where I break down Supreme Court cases that you can find the most comprehensive breakdown of the slaughterhouse cases there is on the internet there, including all cited authorities, a couple of newspaper articles that talk about some potential fraud in the case. It's pretty interesting looking. I'm actually waiting to hear back from the Louisiana Historical Society to see if I can get the case where all that is talked about. But after that, you can go to the Thought Crime Dojo and you can follow my research as it happens. All of the resources we will be talking about today will be available there, as well as all of the resources from my other shows. You can poke around. There's tons of great information over there, documentaries, documents. You can check out my picks of the week, where I pick a specific piece of media that I find particularly interesting, give a little background on it, post it up. But that's enough for the business. Let's get to why we are here today. Let's introduce our co-host, Whitestone. How's it going, Whitestone?
I'm doing well. Very cold, but doing well.
Yeah, it is cold. Had a artificial cold front we feel blowing in right now is
it's all fake. Yeah, you know, when it really gets down to it, you realize it is all fake.
Yeah, absolutely. Yeah, so anyways, let's get to what we're going to talk about today. We're going to get back to Murray F. Tully's speech to the bar from 1903. We're going to get to the second equity maxim that he talks about in this speech, which this is actually a little bit of a shorter one. So we're going to go through and we're going to read this verbatim into the record, and then we're going to give some commentary on it. After that, we're going to riff for a little bit on some of the notes that Whitestone's brought and just kind of dig into the maxim a little bit more. And in hour 2, we are going to dig into a couple of Supreme Court cases that talk about equity looking to the intent rather than the form of some contracts. So, and I always like to bring these Supreme Court cases to give some, it's really concrete evidence to equity. There's really no higher authority than the Supreme Court in our country. So if we can get them saying these words, that I think we're heading in the right direction. Unless, do you got anything to add before we get taken off?
No, I think we should just jump right into it.
Okay, sounds great. All right, with that said, we are going to start reading from page 17 of Murray F. Tully's speech to the bar of the state of Illinois in 1903 that he was the president of. Okay, so here, number 2, equity looks to the intent rather than to form. The above statement of this maxim by Pomeroy is not given by either Story or Bispham as a separate maxim, but is treated by the latter as applicable to penalties and forfeitures, to wit, equity suffers not advantage to be taken of penalty or a forfeiture, where compensation can be made. So Beach has it, equity regards substance and not form, end quote. The principle of this maxim affects to a great degree the entire system of equity jurisprudence. It is so closely connected with the maxim that, quote, equity regards as done which ought to be done, end quote, that some writers have not treated it as a distinctive maxim. It is only by looking to the intent rather than the form that a transaction may take, that equity is able to treat that as done which in justice and good conscience ought to be done. The principles of the two maxims aid each other. The one thing that more than any other marks the difference between proceedings at law and those in equity is that those at law, when not modified by the adoption of equitable principles, are based upon the form of the transaction or instrument, while the equity invariably attempts to get at the substance of the transaction and to ascertain and enforce rights and duties growing out of the real relation of the parties. It never suffers the mere appearance or external form to conceal the true purpose and consequences of the transaction. Uh, yeah, that's a great little way to put it. And that's in the two Supreme Court cases we're going to talk about in the second hour. We're really going to dig into that kind of principle right there, pretty deep. The principle of this maxim was recognized at a very early day by granting relief against penalties and forfeitures. The old common law paid great attention and deference to pure form, and it was an inflexible rule to exact performance of every covenant and promise. At law, whenever a contract provided for a penalty or forfeiture, the full penalty or forfeiture would be enforced without regard to the amount of the damages actually sustained by reason of the default. But it soon became settled law that whenever a penalty or forfeiture was merely to secure the payment of money or the performance of some act or the enjoyment of some right or benefit, equity would regard such payment or performance as the real intent of the instrument, and the forfeiture of penalty as merely an accessory, and would relieve from the penalty or forfeiture whatever the actual damages sustained could be adequately compensated in money. Equity will not, by its affirmative action, enforce a penalty or forfeiture, but will remit the parties if it cannot give relief by compensation or specific performance to their remedy at law. Um, so, I mean, I would say that this maxim really, I would say it deals with contracts more than anything, is what I'm starting to realize about it.
And you're talking about more like the arbitration of contracts when there's a dispute between agreements between two people, rather than looking at just what the words on the paper is. They look at what was the intent of the parties when they signed the contract, what was their actions, in the course of carrying out that contract. It's like they'll disregard the form in the paper if it would deliver more justice.
Yeah, that's what it seems like, and it seems like in like all of the cases that I've brought, that's what they all are. They're all basically contract cases, and one of them even, one of them we're gonna talk about. It's a pretty good one because it's actually, it's an interesting case because at law they actually did follow the law to the T, but equity came in and said, yeah, sure. The form of what you did was yeah, it was legal, sure, but what the substance of your act was uh purely I guess how would I say it? Purely inequitable, I would imagine, because it got all the way to the Supreme Court, and the whole the whole contract was undone. And we'll actually it's a very interesting case. I don't want to get into it too much here, but yeah, it's I just think it's very interesting that they in that case they followed the law to the T, but it still was their actions were reversed because it was an inequitable action.
Yeah, it's like kind of like what we were talking about, equity follows the law. Equity will also not allow an inequitable result to kind of materialize at law. So if somebody is using the form and substance of law to do some inequitable act, equity will step in and prevent that act from taking place because it's not justice. Even if it's at law, equity will still step in and make sure, like if it's between two corporations or whatever it might be,
Hmm.
equity will step in and make sure that justice is done and no nefarious things are being done and nobody's trying to pull one over on somebody else just because the law can't see it.
Right. Yeah, exactly. And that'll make a lot more sense once we actually get into the Supreme Court case a little bit later. You'll actually be able to kind of see the mechanism behind how that works. Um, yeah, I think that's all I got for now, though. You want to keep
Yeah, I'll go ahead and pick
read this
up
next little
where you left
section?
off. So, in enforcing the principles of this maxim, equity created what was known as the equity of redemption of the mortgager,
Mm,
representing an equitable right of the mortgager after the legal title of the mortgagee had become absolute by the non-performance of the conditions of the mortgage. It not only created this estate of the mortgager, this equity of redemption, but subordinated it to the legal title of the mortgagee. It treated the condition of forfeiture as a penalty only intended to secure the payment of the debt. It decreed that the mortgager might redeem upon the payment of the debt with interest, notwithstanding the forfeiture which had taken place at law. It went further in order to preserve the equity of the mortgager and decreed that this right of redemption could not be given up, waived, or parted with by any stipulation or covenant contained in the deed or mortgage. The whole system of equity jurisprudence presents no finer example of the triumph of equitable principles over the arbitrary and unjust dogmas of the common law than this. It's really interesting. Equity basically says that regardless of what's in the contract, what's in the covenant or the agreement, the mortgager cannot waive their right of redemption, um, which is
yeah.
which is great. So even
Mhm.
right then and there, they're disregarding the form and disregarding the substance in order to preserve the right of the mortgager, or whoever might be holding, a beneficial interest.
Yeah, and I mean, we can probably do a whole ep podcast series just on the equity of redemption too. There's so much packed into that one paragraph right there.
Absolutely.
Uh,
Yeah. And thing is, mortgages are really not as difficult to understand as most people would think. Really, everything is just trusts, mortgages, waiver, and consent. And if you can get those four things, you'll be able to understand a vast majority of what goes on.
yeah, yeah, I had just realized the mortgage thing lately. That just, I just, obviously I knew about the trust thing, but the whole mortgage thing just came to light lately for me. So I'm just digging into it, but going through I sent you that one thing, the whole study guide for the equity of redemption in the Bible.
Oh,
And,
right, right.
yeah, yeah, I mean, yeah, it's amazing how much is packed into this little paragraph right here.
And,
And
and
we could
it's
just,
interesting because at common law there was actually no equity of redemption, when it
mhm,
came to mortgages, because if somebody wanted to buy a house, for example, they could not get the house until payment was made. There had to be, one for one. It's like, nope, the
mhm,
house is this much. I have to get this money. Whereas, under the system that we are under now, where you can invoke the equity of redemption, you can actually, whatever it is that you're mortgaging, you can hold on to and use and possess and enjoy and, pay for it monthly
mhm.
or whatever the stipulation might be. But if you end up defaulting on it, you have to give the property back. The equity of redemption says you can go back and get all of the money that you had paid towards that collateral and to make yourself whole. So the mortgagee gets their collateral back, they can have the house, whatever, and you can get all of your money back. And that really is the crux of the equity of redemption,
Yeah.
which is great because you can have a 30-year mortgage and for 29 years and 11 months make all of those payments, and you default on that last month. They're going to come in and take the house, and you say, okay, you know what, that's fine, take the house, but I'm going to get all my money back.
You
All
know,
last.
sorry, were you done?
No, yeah, go ahead. I
Yeah.
was just gonna. Yeah, go ahead.
Uh, so I was gonna say, I've read a little bit of Palm around the equity of redemption, and the system that you just explained, the equity of redemption. I guess that's apparently a uniquely American equity jurisprudence thing. So in English equity, it works how we think it works here now. Like if you default, then they just take the property from you. He goes into the history of it pretty deeply. It's really interesting that's I think it's interesting that it's actually a uniquely American thing
Yeah,
for.
that's why, American English equity jurisprudence is something to be very familiar with because that's where you really can enforce a lot of your status and a lot of your rights under the American equity jurisprudence.
Hmm. It's just very interesting how much it's become refined. So because we brought it from with us from England, but we've just made it even better. Well,
Yeah, because we got rid of or we dispensed with a lot of the confusing estate language that comes
hmm
from England and just really dialed it in to make it a lot simpler for people to enforce their beneficiary status without having all these crazy chains of titles and everything else.
Yeah. Yeah, thank God. Honestly. Yeah, right on.
All right, so we'll continue. Um, at common law, a seal was conclusive evidence of a consideration, which could not be overthrown by evidence. Equity, disregarding the form, while it required a consideration, permitted want of it to be shown, notwithstanding the seal. At law, a sealed instrument could not be discharged except by an instrument under seal. Actual payment accompanied by writing not under seal would furnish no legal defense to an action brought upon a sealed instrument. It is easy to be seen how obnoxious such a doctrine to the principle of this maxim. Equity followed the maxim, even to the extent of canceling the sealed instrument. This was one of the first tests by which equity broke in upon the rigor of the common law. Under this maxim, equity gave relief in cases of imperfect execution of legal instruments, as, for instance, of a deed or mortgage lacking a seal, which was necessary to make it the instrument it purported to be. Equity would treat the same as an agreement to convey or give a mortgage, and thereby created an equitable interest or lien in the land out of the very instrument which the law would treat as a nullity. So that's really important because that right there is looking to the intent. It's like you didn't plug in the device correctly. What did you mean to do? Okay,
Mm-hmm.
great. We'll run with it that way. If you have any other legal instruments, like if you're going to go down the private citizen route, and making beneficial claims, things of that nature. If the law is going to look at those things, well, you forgot a comma here, or there's not a period there, or your name maybe was not written the correct way. Equity is going to look at the intent. It's like, what were you intending to do? It's like, well, I was intending to claim all of my God-given rights that were um, intended for me,
Yeah, or granted to me by the creator. Yeah.
granted to me by the creator, and they were
hmm
intended for me, and this is the document that I'm putting forward to state that claim. And equity will look at it and treat it as valid. Whereas the law, like if like an IRS form, for example, you miss one little thing on there and they're going to hone in on it and tell you made a
hmm
mistake, even though
Yeah.
that might not have been your intent.
Yeah. Yeah, absolutely. Absolutely. And this goes back to like, you know how a lot of like contract people in this whole law thing say like that we're not subject to the Constitution because we didn't sign it. But according to equity, which some of the circles out there believes that the Constitution is a trust instrument, and I go along these same lines. There's really no proof of that, I wouldn't say, besides the language that's in the instrument. But going back to the equity maxim of equity looks to the intent rather than form, the reason we are allowed to use the Constitution as our authority is because it was intended for us.
Yeah,
You
because
know?
of the posterity, because it
Right.
mentions the posterity, which means
Exactly.
anybody that comes after us that claims that we are. Because one thing about the Constitution is it doesn't say who we the people are. It
Mm-mm.
does. There's no outline. There's no definition that says, when the Constitution says we the people, they're talking about this specific group. They left it up to the posterity for you to raise your hand and says, I am one of we the people.
Hmm.
I am
One
heir
of the
and
posterity.
posterity. And
Hmm.
so that right there is what links you in to the being able to claim your status, being able to have title, and being able to operate under a beneficial interest of your name and estate. And so that's, I think, the kind of the claim right there. So yeah, it really could be treated as a trust instrument if that's what you are claiming.
Yeah. And yeah, and I would say doing some of the things in the process that we do, I would say that that is how we use it because um that is our authority that we claim. Um all
And that was
right.
the end of it. I mean, that
Yeah.
is the end of that maxim where he expounds on the maxim. There really is only about 2.5 pages, and if you just think about the maxim, it really does tell you everything that you need to know. And even Tully earlier on in the speech said that he would be okay with doing away with all of the body of jurisprudence, all of the law books and everything, and just stick to the maxims themselves and pick and choose which maxims apply to which scenarios without having to comb through all of the jurisprudence because they are that exact and because they are very easily understood by the layperson.
Yeah. Yeah, absolutely. Sorry, I was looking for this little breakdown of the maxim that I have over here, but I can't find it. Um, shoot. So were you able to pull anything from Pomeroy or anybody to uh did you have any notes on?
No, I all I did was I had redlined this speech a while back. Some things that really stuck out to me, and I actually wouldn't mind going back to some of these things,
Okay.
some of them.
Yeah.
Um, because really, I mean, we're learning out loud. A lot of it is you go through and read it, think about it out loud, come to a conclusion, and then try to pair that against reason and common sense and see if it clicks. And if it does, then you know it's true. And the
Mhm.
first thing that I had underlined in the speech was actually in the second paragraph. Um,
Okay.
it is only by looking to the intent rather than the form that a transaction may take that equity is able to treat that as done which in justice and good conscience ought to be done. So he's really kind of pairing off of another maxim there, which is
Hmm.
equity sees as done that which ought to have been done. I mean, like, for example, in the construction world, there's contracts flying around, agreements flying around all day long. And
Hmm.
oftentimes what happens is any time an undertaking or an operation begins taking place, it's because there was a specific agreement, whether it's between, a general contractor and their subcontractors, or between the city and a large company. That pretty much sets the rules of the house. But a lot of times, the agreements on how work actually gets done is not going to be found on paper. It's going to be between word of mouth or handshake agreements between whoever the foremen, superintendents,
Hmm.
or captains of the team are on the ground. And then if something goes wrong and there's some sort of a dispute, they're going to look at what agreements were made, and that's what's going to be enforced regardless of what's in the contract. And I mean, I have seen that over and over and over again, the last 10 or 15 years, which is why I think the building world, people who build for a living, truly do understand equity, because you're doing equity all day long when you're on the ground out there working and building and having to figure out workarounds. It's
Yeah.
about your intent. Now, if push comes to shove and the attorneys want to get involved and then rip out that ironclad contract, they can do that. But oftentimes, a court of equity is going to look at the bundle of um, like on the fly man-made agreements on the ground, and that's what's going to be enforced.
Well, and I mean, even in that situation, I mean, for, I would assume that you would have to be a private American national, but even in that situation, couldn't you file a bill in equity to get it in, uh, to get it in chambers in an exclusive equity?
I think it probably depends on the situation. I would say that if you're if you are a private American national, but you're operating in your I don't want to say maybe corporate, public, commercial context through your all caps name and agreements and things like that, you might be able to argue on the public side all day long. But if you're in a concurrent jurisdiction, you can still invoke equity principles, and they will use equity in determining the outcome of the case, even if you're at the at-law side, if you're at a concurrent jurisdiction. So if you're running your own company, like an LLC or a small construction business or something like that, knowing equity is going to be a massive tool that you can have in your bag all day long, because you've got that ironclad agreement, that contract that gave you your scope of work, that outlined all of your operational procedures. But sometimes things change and you have to
Mhm.
make on the fly agreements, and it's those agreements that you absolutely can enforce and invoke equity on. Now if it comes to your own body, you as a person in that agreement, then at very least you probably could move it into chambers if you absolutely had to. But I think a lot of that stuff can be done on the at-law side, invoking equity principles if you do it right.
Yeah, I would say that's true because I mean the way it sits right now is they have it all muddled up anyways. They've taken a lot of the
Yeah,
the equity tools, I guess you could call them, is as far as like filing paperwork and stuff like that goes. And
absolutely. And a
yeah.
lot of these concurrent jurisdictions, and the best way to find out is go to your state's constitution, look in their judiciary.
Hmm.
And if their judiciary says that the distinctions between equity and at law are hereby abolished, but they will protect private wrongs or private rights and the redress of private grievances, things like that, they're telling you they're sitting in a concurrent jurisdiction.
Hmm.
Oftentimes they'll say something along the lines of, there will be one civil action for literally everything. And trust me, they mean that. Um, when they are sitting in a concurrent jurisdiction, at least in a lot of the Western states that I have seen, is they are going to try to default to the at-law side in all cases possible,
Oh
and
yeah.
only give you equity if you truly know what you're talking about and you have to push for it.
Yeah, and
So,
in no way will you ever know if you're winning or not. They're never going to
no.
indicate, they'll never give you any indication that
Yeah, if
that
they
what you're
don't bring
doing
the
is working.
hammer, if they don't bring the hammer down on you and you're not losing, you have to get used to that being winning. Silence is
Yeah.
winning. Um, if they are changing their procedure to try to uh, get what they want, and they're kind of acting out of step, and you see them a little bit kind of what do you call it, harebrained or whatever,
Hmm.
that's how you know that you are winning, is because they're having to scramble to figure out what to do.
How to get you
But
back in their jurisdiction. Because
absolutely.
yeah.
But the next thing I had underlined was that it never suffers the mere appearance or external form to conceal the true purposes and consequences of the transaction. And so equity is basically saying that if there's the mere external form, the superficial outline, that the contract or the words, it's not going to suffer that. It's not going to see it as a roadblock. It's not going to see it as an obstacle. It's going to look at the true purpose. It's going to look at you.
Hmm.
It's going to look at your soul. It's going to look at your hands. It's going to look at your behavior. And that is what determines the outcome of the case, not what is on paper. So for anyone out there, even if you have a contract, that gives you a little bit of leeway here or there, if you act responsibly and honorably and honestly, all in all cases and in all instances, you are doing yourself a huge favor, because later on, if push comes to shove, you can actually whip out evidence of your good behavior or your due diligence, even though it wasn't in the contract. And that's another layer of protection where equity will come in and recognize that.
Yeah, absolutely. And that works both ways, whether it be in your favor or against your favor, as we're going to find out in one of the Supreme Court cases later. They will see your evil little heart trying to
No,
trying to
absolutely.
get out of stuff. Yeah. Um, so did you have anything else highlighted out of this?
Um, not nothing that we haven't already covered.
Okay.
I kind of would just like to say that, it almost seems counterintuitive, but when you are really trying to understand equity, if you go back and just adopt the mind of a child and trying to understand these, it will make a lot more sense. Like for example, when you're young and you're drawing something and you go to show your parents, and let's say you try to draw a spider and you're not very good at drawing spiders and everybody knows it except for you. And you're like, hey, dad or mom, look at this spider that I drew on the paper. And they look at it and they go, oh, that's wonderful. That's great. And the mom and dad, whoever, looking at each other, thinking, okay, well, we know what he meant. I can see where they were going here. We're going to put a gold star on the paper, say, you know what? You did good. Good job.
Hmm.
That right there is equity looks to the intent rather than to form. Because everybody
Hmm.
knows that what that child drew is nothing even remotely close to being considered a spider. Um, but because you had true intent and purpose, and that's what you intended to do, they're going to go ahead and allow it. Unless it's so far off the mark, maybe they'll give you a little pointer here or there. Um, you know, that's
Well, and
why
I
I've
mean,
really
you can
never
even do both. You can give them full encouragement while offering helpful advice
absolutely
at the same time.
yes, and that 100% is how I view equity.
Hmm.
Rather than like if you're in an art contest or something, and whoever draws the best one, then you're really looking at the form, because people are really going to scrutinize it and they don't care about what your intent and purpose was. It wasn't the best one.
Yeah. Yeah, yeah,
But anyway,
absolutely.
I just wanted to bring that up because anytime I read these maxims, sometimes it seems like it can get kind of convoluted when we try to use our programmed, brainwashed adult minds trying to pick this stuff apart. But when in all reality, I mean, these maxims are the best expression of the highest truth that we kind of guide ourselves by going through life. And because of that, they should be easy to understand. So if you go into this with just the simplest mind possible and read them and just try to look at it from that perspective, it
Mm.
becomes much easier to see how they can be applied in a more complex manner later on when you get into a Supreme Court case, or when you get into, an entanglement at work, or, let's say some commission somewhere, some state agency thinks that they have a right to drag your body in. Knowing
Hmm.
these maxims and being able to use them appropriately, um, it will help you out quite a bit.
Yeah, yeah, it will help you out, and it's the only, and honestly, it's the only thing that I have seen people, that I have seen help people. I mean, well, I guess that's not true. I guess I have. You can win at the outlaw side. I can't say that I have seen people win at the outlaw side, but man, it looks like a whole lot of headache and a whole lot of fighting, and it looks like people are acting like enemy belligerents to me.
Yeah, and they have to be. And
Yeah.
where did I don't remember where I heard this, but we have, in at least in this country, what's called an adversarial system of law.
Hmm.
And it's meant to be that way, because when you're
Yes.
going in to court at law, you are automatically considered adversaries of one another. And the so-called war, or the battle between you and the other person, is being refereed by a judge or a magistrate. And by its very nature, it is adversarial. And equity
Hmm.
does not do adversarial, equity does justice. And equity
Hmm.
looks at clean hands, people that are not interested in going to war with one another. Because equity is also not going to allow you to just destroy somebody at law, or,
No.
or destroy somebody in court. Equity is going to say, look, You're both very amped up. Sure, there's money, there's property, there's maybe children or whatever it is that's involved. We're going to drop swords and we're just going to look at brass tacks and figure out what the best thing for everybody is. And that's how we're going to make a decision, which is not what the adversarial system of law encourages.
Yeah, yeah, absolutely. And that brings, I actually, I've looked up, did I? Yeah, I looked up a couple of definitions because I thought that would be helpful of substance, form, and intent. Um, I meant to do this earlier. Sorry. So let's just bolster these points, unless you got something else that you would like to bring up. Let's look at a couple of definitions so we can kind of bring it full circle. Um, and the first, hold on, let me link this one real quick. The first, let's look at substance first. What is the definition of substance? And this is out of um, Bouvier's Law Dictionary. That which is essential, it is used in opposition to form. It is it is a general rule that on any issue is sufficient to prove the substance of the issue. For example, in a case where the defendant pleaded payment of the principal sum and all interest due, and it appeared in evidence that a gross sum was paid, not amounting to the full interest, but accepted by the plaintiff as full payment, the proof was held to be sufficient. That is the definition of substance. Okay, so that second little part right there. What is, do you understand what he's saying right there?
So, in the definition of substance here, I think what it is doing is it's drawing sort of a juxtaposition just in the way that it explains it. It's drawing a juxtaposition the way the common law would view satisfaction for payment versus equity. So, under the common laws we read earlier, the payment or the satisfaction is not considered complete until whatever amount is written on the paper was handed over. So, for example, if the agreed upon amount or payment was, let's say, $100, the common law would say this is not settled until the defendant gives the plaintiff $100 according to whatever's on the paper. Now, let's say that outside of court or before they even got to court, the defendant had given the plaintiff $50 and the plaintiff accepted it and still took him to court, not for the resulting amount, but for the full amount. Equity would say, well, the plaintiff did give you money, you accepted it, and you didn't ask for the rest of it. We're going to consider that payment as valid. Even though the paper says 100, he gave you 50, you didn't say anything. So we're going to say that it's the substance is he did pay you. No, it wasn't what the original principal amount was. However, your tacket, is it tacket or tacit?
Tacit.
Okay. Yeah, so your tacit agreement or your acceptance of that 50 without any further stipulations of receiving the rest of the money, equity like, okay, he paid you. You accepted it, he paid you, it's done. So the substance was, yes, a payment was made and you accepted it. Even though the paper says 100, you accepted what he gave you. You didn't disclaim it or ask for the rest. So in the substance of it, yes, you were paid.
Yeah, so accepted by the plaintiff as full payment. The proof was held to be sufficient. Yeah, okay. Interesting. Nice. All right. So, and the reason I bring up substance is because, like, the intent, the equitable maxim, equity looks to the intent rather than the form. It goes with a couple of other equity maxims that are one of them that is the next one actually is grouped in there. Equity regards that as done which ought to be done, which I'm excited to get to that one, which that's going to be a pretty juicy show right there. But they kind of all fall under the equity looks to the substance rather than the form, and intent just gets a little more specific with it. But So what is intent? And I did not find a definition of intent, and I didn't get a chance to look in Black's, but I did look in Bouvier's, and I did not see one in there, which I thought was interesting. But um, so I got it out of actually the 1828 version of Webster's dictionary. And so the definition of intent from there, the adjective is literally having the mind strained or bent on object, hence fixed closely, sedulously applied, eager in pursuit of an object, anxiously diligent, formerly with to, but not with on, as intent on business or pleasure, intent on the acquisition of science, be intent on. Okay, no. And then the noun is literally the stretching of the mind towards an object, hence a design, a purpose, intention, meaning, drift, aim applied to person or thing. The principal intent of Scripture is to deliver the laws of duties supernatural. Okay. So that's the definition of intent, literally the stretching of the mind towards an object. I like that definition of intent right there. Stretching the mind towards an object. Where was your consciousness uh, planning to go? Where was it? Where were you trying to place your consciousness? So do you have anything to say about that before we move on to form?
Yeah, it's interesting too for those who have read the Kabbalion that they
Mm,
define meditation as a mental reaching out or an extension towards some end, because that's your intention. Whether it's meditation or whether it's prayer or just a solemn sort of contemplation where you're contemplating something, is it's a mental reaching out towards something that
hmm
is your intention. And
hmm
so you can look at that in regards to this maxim as well, that, or like I'll say it was a contract or your behavior, whatever it might be, what the intent was, what were you reaching out towards mentally, what was the desired goal, um, or what
What
was
was
the
the
desired
frequency you
effect.
were trying to reach? I guess you could.
100%.
Yep. Yep. So
And
since you brought
I
up the
also wanted to
Kabbalion.
say that it looks like, just I was just looking over Pomeroy's equity jurisprudence. I'm looking in the third edition, section 378. That's where he really goes into the maxim that we're talking about. And it
Okay.
looks like Tully pulled pretty much straight from Pomeroy.
Oh, really?
Uh,
Okay, nice.
yeah, because I'm reading 378, and for a moment I thought I was reading Tully's speech because he almost takes it one for one right out of Pomeroy. But Pomeroy actually goes into a little bit more depth about why two maxims actually work together. Equity looks to the intent rather than to form, works synchronistically with that which equity sees that as done, which ought to have been done. So he said, in explaining the meaning and operation of the one maxim and the effects produced by it, I have necessarily described the significance and workings of the other. The two principles act together and aid each other, and it is by their universality and truth that much of equity jurisprudence, which is peculiar and distinctive, in contrast with the law, has been developed. So Pomeroy is even telling us right then and there that those two principles, it looks to the intent rather than the form, and it sees as done that which ought to have been done. He's basically pegging those two as the entire basis of all equity jurisprudence.
hmm Yep. Yep. And what was that last line you just read in there? I can't remember.
Let's see. The two principles act together and aid each other, and it is by their universality and truth that much of equity jurisprudence, which is peculiar and distinctive in
Mm,
contrast with the law, has been developed. And then he goes on further. Equity always attempts to get at the substance of things and to ascertain, uphold, and enforce rights and duties which spring from the real relations of the parties. It even says it will never suffer the mere appearance and external form to conceal the true purposes. Basically, Tully copy and pasted this right out of Pomeroy. But the thing is the real focus here is on using that word again, the real relations of the parties. Like
Hmm.
you can have a piece of paper between you and another person that outlines who gets what the responsibilities and the duties are, yada, yada, yada. But when it comes right down to it, put the paper aside and look at those two people and say, okay, but what is the actual relationship between you and this other person, regardless of what's on the paper? And that's
Hmm.
what it looks at. It's very, very important because the adversarial system of law that we are currently being dominated by does not really allow for that at all. And I think many people out there that throw their hands up when they get frustrated with this system, um, they are really calling out and reaching out towards equity principles without even understanding what equity is because it's
Hmm.
inherent.
Hmm.
If you feel that, so, well, that's not what I meant. I didn't mean to do that. Now I'm getting this piece of paper from a government, or now I'm being sued. And it's like, whoa, whoa, there's a huge misunderstanding here. Equity will sit down and listen to what it is that you have to say about it, and then they will proceed rather than looking at the paper and ignoring you.
Well, okay. So, all right. Yeah, that's awesome. So we'll go ahead and unless you got something else, we can go ahead and move on to the definition of form, if that's
No, yeah,
cool.
that's right, because we can do that. Otherwise, I'll just continue to read right out of Pomeroy.
Okay. Well, I mean, if you think there's something else relevant, we can keep going in that for sure.
It's really sections 1 through sections 1422. So maybe we just stick to the definition.
Okay. All right. All right. Yeah, we got about 10 minutes left, so we'll
All right.
get into the definition of form here. Form is the model of an instrument or legal proceeding containing the substance and the principal terms to be used in accordance with the laws, or in its act or pursuing in legal proceedings and in the construction of legal instruments, the order required by law. Well, that's an interesting little opening right there. Is the model of an instrument or legal proceeding. That's the form of something containing the substance and the principal terms. So,
It's very crazy because what do they call these pieces of paper that you send to the IRS or that you send to, whoever else? They call it a form.
form, yeah, they're all forms.
I mean,
Form this,
it says it right at the
form.
top.
Yep.
Fill this form out. If like I'm looking currently right now at a W4, 2020 or the W4 2026 from the Treasury, and it actually is right in line with the definition because this piece of paper, it's the model, right? And on a model,
Mhm.
you usually have different pieces and aspects that form the picture that you're trying to paint. So when you look at a form and all the words on there, this is the picture that is being painted, and they're all in accordance with the laws. Um, but a lot of forms, a lot of people don't know this, is unless it's very, very specific, it cannot be altered. You can alter forms all day long.
Absolutely.
You can white things out. You can write your own things in
Hmm.
there. You
Handwriting
can restrict.
always takes precedence too.
Yes, and you can
Always.
restrict your signature. You can change language on there because really, forms and paperwork really is court if you think about it.
Yes.
Because, like, if you were to be 100 feet above a basketball court and you look down, it's about the same shape as the size of paper.
Yeah.
And that's what it is. On the court, there are rules, and on the form, there are also rules, and you have to, work within those rules. However, in the world that we live in, you can alter these forms and you can send them in, and if they don't disclaim them or they don't send it back, it's as good as gold.
Because those forms contain the substance and the principal items. So
Yeah.
whatever's on that, that's like I just said, handwriting takes precedence over everything. So it doesn't mean, and he didn't say that you filled in the boxes and that's the substance. He said it contains the substance and the principal
Yep.
items. Um, so I'll just keep reading this. This will probably be a pretty interesting definition here. Um, so use for pursuing construction legal instruments, the order required by law. Form is usually put in contradistinction to substance. For example, the operation of the statute of 27 Elizabeth, whatever, all merely formal defects and pleadings, except in dilatory pleas, are aided on general demur. The difference The difference between matter of form and the matter of substance in general under the statute as laid down in Lord Halbert is that without the right, without which the right doth sufficiently appear to the court is form, and that any defect, quote, by reason whereof the right appears not, is a defect in substance. Okay, so wait, what? Okay, let's break that down a little bit. Under this statute, as laid down by Lord Hobart, is that without which the right doth sufficiently appear to the court is form. The right doth sufficiently clear as form. To the court, appear to the court as form. And by reason whereof is deficient.
So I think what he's talking about there is a defect in, because the thing is, like, there can be a defect in the form and there can also be a defect in substance. If somebody is claiming that they have a right, they're going to look at the form, and if they can't find where that right appears in the form, maybe they'll look at the substance to see if they can find where it is that that right is appearing. And if neither the form nor the substance of that form indicate that there is a right, the court will probably assume that there isn't one, because it's not evident in the form and it's also not evident in the substance. Therefore, whatever is being pleaded cannot be enforced because it appears in neither. I would assume that's,
yeah, the right appears not. Yeah, so yeah, that's it, right. So that makes it deficient in substance.
That's that old English where they talk in the cadence of Yoda and you have to read it backwards in order to figure out what is going on.
Yeah, that's why I was like, okay, we better break this down a little bit.
Because he starts off by saying that without which the right doth sufficiently appear. It's like, what are you saying?
Right. Yeah, I feel like you're doing way too much there, dude.
Yeah, okay, Lord Hobart, let's just
calm down, buddy. Calm down.
Yeah, that's why it's like, okay, put the form down. I'm just going to start talking, and that will be the substance. How about that?
Exactly. Yep. That's exactly. All right. So a distinction somewhat more definite is that if the matter pleaded be in itself insufficient without reference to the matter of the pleading, the defect is substantial. But that if the fault is in the manner of alleging it, the defect is formal. The matter is sufficient without reference to the manner of the pleading. It is without reference to the manner of pleading.
So that's, I think, if they're saying that if the matter pleaded be itself insufficient without reference to the matter pleading it, the defect is substantial. Oh, so that way it's like, it's like what issue is being brought before the court. That's the matter. If the matter that which is being pleaded is insufficient without even talking about the way in which they pleaded it, the defect is substantial, because that means that this is a non-issue. It's not that you didn't file it correctly or the form is not right. It's that the matter itself is of no consequence.
There's no substance to your argument.
Yeah, there's no substance to the matter. We can't hear this because there's no guts to it. So I think that's kind of what he's looking at.
Making the defect substantial. So there's no substance
but
to
it says that if the fault is in the manner of alleging it, the defect is formal. So that means that the matter brought before the court is probably warranted. It's good, but the way in which they are pleading it is incorrect. So therefore it's a formality. But so because that the matter before the court is valid, but the way in which it was pleaded was bad, that's when maybe they'll open up equity, be like, I'm sorry, what are you saying? Like, it's like, there's property here.
We see there's substance to your argument, but you're fucking this paperwork all up.
Yeah, it's like, because it looks like you wrote this with your left hand when you've never written with your left hand before. So what are you saying? And then that's when they open it up to equity. and they look at the intent. It's like, man, he scribbled all over this plea. I don't know what he's writing.
I don't know
He
what
must
the
be a
fuck.
sovereign citizen because this makes no sense.
Yeah, got him.
Yeah, it's like, oh, you didn't sign the Constitution? Guess what? Nobody in the last 150 years did either. If you just understood equity jurisprudence, you would claim one of we the people, beneficial interest, posterity, trust language, and that's how you would go about it. But you're a lazy sovereign citizen, spends
Mhm.
all day on Telegram and TikTok, and you don't know
With
anything.
protection
Sorry
by
to
the
swear.
14th Amendment, by the way. With protection through the 14th Amendment, by the way. We should throw that in there.
Yeah, absolutely. And that's the thing is like people say, oh, I mean, like, Eric talks about, the evil 14th Amendment, but it, on one hand, yes, it is a
Well, he
chain.
talks about it being a double-edged sword, is
It
what he
is.
talks
Yeah.
about it.
And that's
Yeah.
what I was getting at is it
Yeah.
is 100% a, a double door, however you want to look at it. And even the Bible talks about that, art thou not a servant? Why not use it?
Why
And
not
if it
use it?
says
Yes.
that, because the 14th Amendment is your protection on a state level. So it's like,
Hmm.
okay, fine. You're locked into this thing, but just claim beneficiary status all day long, either at the federal level or the state level. Don't
Hmm.
don't throw it in the trash.
Yeah, it can be used as a tool of usurpation, or it can be used as a tool of freedom.
Yep,
It's a
just like
double.
anything. You can
Yes.
commit the most atrocious crime in the world with a hammer, or you can use that hammer to build a house and house a family.
Yeah,
And so that's kind of, I think,
exactly.
what the 14th Amendment or really any of these laws can be looked at. It's like, how can you use this for your benefit and not in a nefarious, advantageous way, but in a way that's honorable?
And I did just want to bring that up because I will say I used to be one of those people that was like, oh, fuck the 14th Amendment. We got to get rid of it entirely, blah, blah, blah. Like I was, on the bandwagon of abolishing the 14th Amendment, but
Yeah.
it's not the answer. That's not the answer
Yeah.
to this shit.
Well,
It's
and that's
just
the thing.
really
It's like,
not.
well, if you're going to throw out the 14th Amendment because you don't like what the Jesuits did, it's time to do some homework and realize that the Constitution was written by the very people that,
Yep.
yeah. So the entire Constitution was basically written and drafted and presented by what do you want to call it, the papacy or the Vatican,
Yeah,
and
it's
England at the time.
yeah, I mean that's a papal document probably, I would
Yeah, it
imagine.
100% is.
Yeah,
100%
so
is. But you know what? If the thing is this creation was made for people who want to claim beneficiary status. Once you go to God and once you go to the light and you are walking in equity, that document will allow it. But if you're
mhm.
not walking in the light and you're not walking in equity, then that document is, a series of giant black holes that you can fall into.
Yeah. Yeah,
And
absolutely. Yeah.
those are the holes that all these sovereign citizens are over there skinny dipping in, thinking that they're doing a good thing, and they're not.
Yeah. 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 So, all right. I think that's a perfect place to leave it for the first hour then. Thank you everybody for coming with us to learn out loud here. We did do a little bit of learning out loud today. We definitely went off the cuff, and we looked up a couple definitions on the fly, got into it a little bit, and I mean, I think it went well. I think we did good. We got into the maxim. And I think we explained it concisely. And if you guys don't feel that way, please let us know. But I think we're trucking right along here, and I really think what we got, we're getting the ball rolling for us. And but if unless you got anything to add, I think we will leave it there and move on to the second hour.
Well, all I'll say is, I mean, in the big world of podcasting, so many people are worried about the glimmer and the glam and high levels of production value, but once again, equity looks to the substance and not the form. So if you've
Hmm.
got if the form of the content that you are producing is pristine, but the substance is not, you might want to go back and look at it. And I
Yeah.
think at least for the episodes that we're doing, equity looks to the substance because that's truly what we're about here is bringing people not coming as an authority, as learned authorities, but saying, "Hey, boys and girls, we found some old books which we think are really interesting. Here's what we currently think about it and how it could help us. Maybe you should
Absolutely.
look at it and use your own brain head and see what you think. Maybe
And
we're
our
wrong. Maybe we're
and
on the right track."
and our ideas are going to morph as we go through this thing. They're going to change, and I'm sure we're going to get a couple of things wrong, and we're going to have to make some corrections, but we are more than willing to do that because we are here learning out loud, trying to figure this thing out, and, trying to get one step closer to freedom every day.
Absolutely. Because this is, this is not operational knowledge where people tune in and figure out what to do. This is sort of hey, maybe here's how to structure your learning or your thinking so that you can figure out what the right step for you is.
Yeah, we're never going to tell you what to do. We're never going to, say this is how you have to do it, this, that, and the other. I mean, there are some things that are mistakes, and we will point those out. But other than that, we're not going to claim to be a guru of any side. We're not one of these law gurus out here trying to, run a community of some sort, teaching people how to pass bad financial instruments and shit. That's not what we're about. We just want to learn. We want to learn the right way. We want to learn the right things, and we want to learn the things that are aligned with the Bible, which is what equity is. So,
absolutely.
So I think that's a great place to leave it. And hopefully we'll catch you guys on the other side. And never forget to seek truth and honor the Creator above all. Let that be the whole of the law.
That's the important thing here, is that everyone's word should be meant for a use.
And the words that I'm using today are meant to pull down idols within people's temples.
Meaning that I want to destroy
falsities that they have idolized
for their entire life.
And just pull those out and sweep them clean. And before that temple,
and get reinfested with a new lie, give it true life.